What would you do if you gave your ex everything in a divorce because they said they were dying, only to find out they might have lied? Today's case is absolutely wild. Mr. Murphy claims his ex-wife faked having terminal cancer to get a better divorce settlement. She got the country club membership, the sports tickets, more time with the kids. Everything, but plot twist. She's still alive and apparently in remission. Is this the ultimate divorce scam or a tragic misunderstanding? The judge is about to decide if this was fraud or just wishful thinking gone wrong. Get ready for one of the most shocking divorce cases we've ever covered.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff and Ms. Capture on behalf of the defendant. This matter is before the court on the defendant's motion for relief from judgment. Ms. Capture.
Thank you, Judge. As we stated in our motion, Mr. Murphy entered into this agreement on the understanding that Ms. Taft was terminally ill, and based on her representations to Mr. Murphy would be dying within the year. The agreements that he agreed to essentially are unconscionable, especially given the fact that there is a massive divide between Mr. Murphy and the children now. He doesn't have the parenting time that he would have wanted, but obviously gave more parenting time to Ms. Taft, given her assertion that she was dying. He wanted to keep things as even for her. Even isn't the correct word, but essentially he wanted to make sure that she would have a decent rest of her life. So they didn't divide the business. A lot of the things that they kept around, like the country club dues, the tickets for the baseball and football or basketball and football games. Essentially he agreed to this on the understanding that she was going to be passing. If she's not, and he has tried to communicate with her and say, hey, what's actually going on? Because I'm being told that you aren't terminally ill, and that you induced me into agreeing to this agreement without under a false allegation. So
okay, let's unpack this bombshell accusation. The defense is claiming Mr. Murphy got completely played. He allegedly gave up the business, country club memberships, sports season tickets, and extra parenting time, all because his ex-wife said she was dying within a year. That's unconscionable in legal terms, meaning so unfair it shocks the conscience. But here's the kicker. He signed without a lawyer. That's red flag number one in any divorce. The defense wants an evidentiary hearing to prove fraud, which will require showing she knowingly lied about being terminal. This isn't just about money. It's about a father who gave up time with his kids, thinking their mother was dying. If this is true, it's one of the cruelest divorce tactics we've ever seen. But the plaintiff's attorney is about to drop some truth bombs of their own.
So essentially, Your Honor, what we're asking for is an evidentiary hearing so we can put proofs on the record to say Mr. Murphy did enter into this agreement under duress, that he believed false information presented by Ms. Taft. Even within his pro-con, he stated, and I'm not going to quote this directly, but he stated an understanding that he was entering into this agreement due to her terminal illness, without counsel, without representation, and simply signed the dotted line due to the misrepresentations that she placed to him. So, Your Honor, we're looking for an evidentiary hearing to prove that misconduct did occur, and then to move forward with this matter. Thank you.
Thank you. Mr. Schaefer?
Your Honor, we have filed an extensive answer to this. Number one, we submit that this is an improper motion for a number of reasons. Number one, the allegations alleged that my client said are not true. Next one is that it's pretty clear that it's under duress, pressured based on the allegations therein. Number three, this was filed because my client hasn't died yet. Well, they didn't even give her a year. It's February 29th judgment. I represent to this court melanoma. It's in remission at the present time. And to
wait, what? The plaintiff's attorney just confirmed the melanoma is real and in remission. This changes everything. So she wasn't lying about having cancer. She actually has melanoma, which is one of the deadliest forms of skin cancer. The attorney's sarcasm is brutal. This was filed because my client hasn't died yet. Think about that for a second. Mr. Murphy is essentially complaining that his ex-wife survived cancer. This puts a whole different spin on the case. Was she supposed to give him a death certificate with an expiration date? Cancer prognosis isn't an exact science. But hold on, because the real bombshell about the business ownership is coming up next, and it's going to blow this case wide open.
That there's something inequitable about this. What is improper on this is that counsel for the other side signed these pleadings knowing that the business was owned by both of the parties. We have submitted evidence of that, and this was filed just before there is a oppression suit that's going to be filed in relation to the division of the business. Client is asking for costs and sanctions in that regard because both the client and the attorney signed pleadings knowing that there's a 50-50 ownership in the business.
Boom. The plot thickens. The business was always 50-50 owned, and both Mr. Murphy and his attorney knew it. This completely undermines their fraud claim. They're asking for sanctions because this appears to be a strategic move, filing this motion right before an oppression suit about the business. In legal terms, that's when one business partner claims the other is unfairly running the company. So let me get this straight. Mr. Murphy is crying fraud about a divorce settlement while simultaneously preparing to sue over a business he claims he gave up. The timing is suspiciously convenient. The plaintiff's attorney is essentially saying this whole terminal illness fraud claim is just a smokescreen for a business dispute. That's a devastating accusation that could get both Mr. Murphy and his lawyer in serious trouble.
Business, my client has never used her melanoma in any way to affect judgment. It was a choice by a defendant not to be represented. He had been represented around this matter and chose not to. That was his decision. Now he is crying sour grapes. His allegation about the children, his relationship with the children at the time was poor at best and did not exercise his parent time at this time. We submit that this motion is unfounded in fact and law, should be dismissed, and that costs should be assessed in relation to the improper pleadings.
Thank you. Anything else, Ms. Capture?
Your Honor, the pleadings aren't improper. Again, this is not so much about the allegations that this is a jointly owned business. We admit in our motion that there's a marital interest in this. Again, Your Honor, this is simply about the misrepresentation by Ms. Taft that she's terminally ill. She induced my client into signing a divorce decree to get this settled so that she could live in peace the last time, however long it was going to be. Mr. Murphy has requested on numerous occasions, can you just communicate with me about what's going on? And she refuses to. And now he is being told by her numerous friends and family that she is not, in fact, terminally ill, nor was she ever.
Hold up. The defense attorney just revealed their evidence is basically gossip from friends and family. No medical records, no doctor's testimony, just hearsay that she was never terminally ill. That's not how fraud cases work. You need concrete evidence, not rumor mill reports. And notice how they're backpedaling on the business issue? They're admitting they knew about the joint ownership all along. The desperation is showing. Mr. Murphy wants his ex to communicate about her health status. But honestly, why should she? They're divorced. She doesn't owe him medical updates. The defense is trying to paint this as compassion. We want her to be healthy, but it sounds more like buyer's remorse. Would you share your private medical information with an ex who's trying to overturn your divorce settlement?
she ever terminally ill, and that he agreed to this under the misrepresentation that she was. Again, Your Honor, we state in our motion specifically that we are just simply asking to have all of this resolved. However, Ms. Taft will not communicate. And if she is going to continue living, which is great, good for her. We want her to be in remission. We want her to be healthy. But if she's going to continue, obviously the marital property needs to be divided appropriately, including the business. That's not to say that we are saying, well, we shouldn't ever divide the property. We simply need an answer, and we need the correct answer, not a lie. If she's going to be passing on, well, then let's get that resolved, and we would withdraw our motion. But we obviously, she's in remission, allegedly. So then she obviously didn't have terminally ill melanoma like she represented to my client.
Well, in this matter, the court does note that fraud has been alleged, but as I go through the pleadings here, the argument, there's been very little factual basis for the allegations. I don't believe that in this matter, the defendant has set forth a prima facie case for the court to again intervene at this time. And so the court believes that if in some time if the defendant can develop those particular facts, then the defendant can file an amended motion in this matter. But at this point, the court doesn't believe that there's a factual basis in this matter other than a he said, she said. And as a result, the court will deny the motion at this time.
The judge just delivered a judicial smackdown. He said, she said, that's legal speak for you got nothing. The court found an no prima facie case, meaning Mr. Murphy didn't even meet the basic requirements to prove fraud. The judge is essentially saying, come back when you have actual evidence, not just feelings and rumors. This is a complete victory for Ms. Taft. But notice the judge left the door open. They can file an amended motion if they develop actual facts. That's the court being generous, because this motion was clearly premature. No depositions, no medical records, no expert testimony. Just accusations based on the fact that a cancer patient didn't die on schedule. The judge even denied both sides' requests for costs and fees, which shows how unimpressed court was with this entire proceeding.
This time, and the court doesn't believe there's a basis for award of costs or fees, so it will deny that request by both parties and ask Mr. Schaefer, you prepare the order denying the motion.
I will, Your Honor. Thank you.
You're free to go. Have a good day.
Thank you, Judge.
Wow. Let's recap this absolutely wild case. Mr. Murphy tried to overturn his divorce settlement, claiming his ex-wife faked terminal cancer. But here's what actually happened. She does have melanoma. It's just in remission. Thank goodness. He gave her favorable terms, thinking she'd die within a year. But cancer doesn't follow schedules. The judge found zero evidence of fraud. Just hearsay from friends and family. The real kicker? This appears to be about a business dispute, not genuine concern about fraud. The lesson here? Get a lawyer during divorce proceedings. And don't expect the court to undo your bad decisions just because your ex survived cancer. This case shows why evidence matters more than emotions in court. If the shocking divorce drama blew your mind, smash that like button and tell us in the comments. Do you think Mr. Murphy was scammed or just his buyer's remorse? Subscribe and hit the bell for more unbelievable courtroom battles every week. Next video, a custody battle that involves a pet tiger. You won't want to miss it.